Hello, everyone. My name is Mackenzie Bretz. I'm a family law attorney here at Beresford booth. Today, we're going to be talking about revisions, reconsiderations, and or appeal. So the title of my webinar today is, Can I revise, reconsider, or appeal my family law order? See if I can get this to move. All right. So your requested relief from the court was not entered. So if you're in a situation where you filed a motion for a temporary family law motion, or you requested some other kind of relief, say that was, a motion to mandate mediation, or you were requesting a gal be appointed, and a commissioner made a decision you did not agree with. This means you can consider revision, reconsideration. We'll talk about appeal very quickly, but appeal likely does not apply to these types of situations. So appeal. You can only really appeal a decision when it is a judge's final order. So this means you go to court, you go to trial on your family law matter. The judge, your trial judge, orders child support, parenting plan, a final decision. These are things that you can then seek appeal on. But remember, an appeal is not a redo. The Court of Appeals will review the evidence that each party originally presented. They will then check if legal errors occurred, and they can reverse a lower court's decision when inadmissible or immaterial evidence influenced the decision. They'll also consider any procedural violations or things of that nature. You have 30 days to file a notice of appeal after a final decision. So while this is important, I'm going to be talking a little bit more about revision and reconsideration. So revision. What is the motion for revision? This is when you ask a judge to change a commissioner's order. What does that mean? In family law, for relief such as a temporary family law motion or a motion to mandate mediation or things of that nature, you're going to go in front of a commissioner. When you're asking for revision, this hearing you had goes then in front of a judge who then reviews the commissioner's findings and order and then decides they want to make a new decision. This has to be done within 10 days of the commissioner's order. So if you received an order on the 2nd, you have to count that day and count weekends, and you have to file in the timeline that is required, or your motion for revision will not be heard. Such revision shall be upon the records of the case and the findings and facts and conclusions of law entered by the court commissioner. This means you cannot provide new evidence. If you have new evidence, then you're going to want to seek reconsideration over revision. However, we'll talk a little bit more about revision, but revision cannot include new evidence. Why would you ask for revision? Great question. You either disagree with the commissioner's decision, or you think the commissioner made the wrong decision based on the facts and the law. So if you disagree, of course, this cannot just be, I'm upset with the order, I disagree, I want to go against what the commissioner said, right? You have to detail why you disagree. Maybe you believe you presented evidence that should have provided you with a certain result, and maybe you believe the commissioner didn't fully consider that evidence. Maybe the commissioner in either their oral ruling or their written ruling didn't specify that they considered certain evidence. Maybe there's a situation where you're asking for a restriction in the parenting plan because the other parent has demonstrated concerning action. And, you believe that the commissioner didn't fully consider all of the evidence that you have presented to them, and this creates a concern for your child, right? These are instances where you can try to further explain to the judge that the proper result wasn't entered. Of course, taking the time and money to file a revision, this cannot just be simply because you're upset or you disagree or you don't like the commissioner, right? You have to have strong basis in fact for your revision. If you believe the commissioner made the wrong order based on the law, make sure you provide case law and the correct law to underline your point. So if a commissioner made a specific ruling and you know specifically that a law doesn't allow this type of ruling, then you can cite the new law, and this can be a very easy and straightforward way for revision. Beresford Booth's attorneys, of course, have quick and easy access to case law and are very experienced in researching, so they can help you formulate a revision motion with such facts. Pros and cons of seeking revision. Pros, get another chance to tell your story. This, however, does not mean you get to expand on facts or create a larger court record, right? But you get to explain potentially a reason that you believe the commissioner overlooked in making their decision. The turnaround on the decision is fairly quick, which is helpful. And potentially a mistake can be rectified, right? We have to think about when we are getting family law motions, commissioners are people too. They sometimes make mistakes. They're not always entirely perfect, which, we sometimes wish they could be, but that's not the case. So this is a way to kind of rectify if it's a wrong decision was made. Cons, filing a motion for temporary orders can be expensive. If you then have to seek revision, this means a motion for revision, declaration, potentially exhibits. This has to be filed. The other side likely is going to file a response. You'll likely have to file a reply. Sometimes the court asks for oral argument on these matters. Sometimes they do not. But that is more time, more effort, more money, especially if you're having an attorney do this. So you have to consider, is this motion practical? Do I have strong evidence to bring it? Because it should not be brought just because someone is upset or angry with the outcome of their hearing. Excuse me. Again, not guaranteed that judge will make a different ruling, right? You can bring a motion for revision and a judge can say, nope, the commissioner made, the right decision. And that can be even more frustrating because it's two people kind of telling you what you believe is wrong, but that can happen and you have to be prepared for that. Every county has different rules. Be careful and check the rules, especially if you are filing by yourself. You want to be very careful that something procedurally isn't going to mess you up or not allow your motion to be heard, especially if you're filing right on that 10-day mark. You want to be sure you're following the rules of the county you're in. If you're in King County, you can look up local King County rules. If you're in Snohomish, look up local Snohomish County rules, right? To make sure that you are following the rules properly to get your motion heard in front of the proper person. Okay, motion for reconsideration. Slightly different. It asks for an entirely new hearing on all issues or some of the issues. And it's asking the same commissioner to reconsider. So while we think about revision versus reconsideration, right? Revision asks for a judge above your prior commissioner to review the commissioner's ruling. Reconsideration asks for the same commissioner to review the same decision. However, in reconsideration, you can potentially provide facts or evidence, right? And if we see right here, are 9 different ways that you can seek reconsideration. So some of the most popular are irregularity in the proceedings of the court, newly discovered evidence, error in law, substantial justice has not been done. So when you're seeking a motion for reconsideration, you have to plead one of these specific 9 errors, right? That is the basis for why you're seeking reconsideration. So if your your error doesn't fall under any of these 9, then reconsideration is likely not the best way to go for you. So this is one of the most popular, right? Irregularity in the court proceedings. Especially in family law, there are times where someone has an emotional or mental breakdown in court, which can then, potentially be harmful to the proceedings. If someone lied in court and you can prove it without any doubt. Commissioner held an unfair hearing, did not let you argue your side of the case. These are some of the potential reasons, kind of falling under number 1. This is a really good area if you want to seek reconsideration or you believe you potentially have an issue for reconsideration, to talk to an attorney who's experienced in this and bringing motions for reconsideration, because they can really narrow this idea down and tell you, yep, I think your issue falls under one of these or it doesn't. So we have reconsideration plus new evidence. So here we're asking, in reconsideration, can you provide new evidence? I said yes before. However, there is a caveat. The judge may allow new evidence if the new evidence is so important that it will probably change the result if you get a new trial or new hearing, and you could not have discovered the evidence before the hearing or trial, even if you had been diligently looking for it. Be warned, the standards are very strict. So if one of the reasons you're bringing reconsideration is on the basis of new evidence, you have to be able to very distinctly demonstrate that this evidence wasn't available to you beforehand. This is because the court doesn't want, a situation where a litigant or a party says, oh no, I left out some evidence, I'm going to re-litigate this issue. So you have to have a good reason. So what does a good reason mean? Potentially you had served a subpoena and you didn't get the information until, after the hearing, and it's very vital information that would change the outcome of your case. Maybe you had some disabilities in being able to access the legal system, which made it harder for you to obtain evidence, right? So these are very extreme reasons, right? It can't be that, you just didn't know that this evidence was relevant at the time. The reasons for bringing new evidence are pretty strong, and a court doesn't want a reconsideration on, essentially a mistake of not providing the correct evidence. A little more on reconsideration. So again, must be filed within 10 days of the order, must be noted and heard within 30 days of the order. That's important. So your filing date has to be 10 days, but it has to be heard by the court within 30. We've kind of talked about this a little bit, but a litigant should not seek reconsideration merely because of dissatisfaction with the decision of the court or a desire to re-argue a motion, right? So make sure that you're serious and have good fundamental reasons to bring one of these motions before you proceed. Is a motion for reconsideration the same as an appeal? No. An appeal asks a different court to change the decision that the court entered. And you generally can't ask the court to look at new evidence in appeal. A motion for reconsideration asks the same court, in our situation, the same commissioner, to change its own decision. So you can think about our legal system. Often some attorneys may say a motion for reconsideration is often tougher because you're asking a commissioner to say that they made a mistake, which is, a hard thing for judicial officers to sometimes agree to. However, if you have strong evidence under one of the 9 reasons, Motions for reconsideration can be heard and can be found in your favor. Looks like it's taking away some of my photos, but that is okay. Important things to consider on reconsideration. These are a little more procedural, but use the proper note for motion docket for the judge who ruled in your case. This means, again, we are putting our motion for reconsideration in front of the same commissioner who heard our last case. Be mindful of which courthouse you file. List all parties on the motion. The other side doesn't respond unless the court asks them to. So if you file a motion for reconsideration, the court will then decide if they want to set a briefing schedule. Briefing schedule means a reply, or excuse me, a response and a reply, right? And if they decide that they believe a response and a reply is appropriate, they'll provide you with a letter with the date the response is due and the date the reply is due. So the court will make a decision if they believe that's appropriate. Do I have to go to the court hearing? Do I have to go to another court hearing for this? Typically, these type of hearings are heard without oral argument unless a commissioner requests oral argument. So typically, you do not have to appear for this type of hearing. Does opposing parties' motion for reconsideration open up the ruling to be modified in whole or part? I think this is kind of an important question, and one I see often. Essentially, we're asking here, you know, if I filed a motion for temporary family law orders and I got the relief I believe was appropriate, other side filed a motion for reconsideration on a certain issue, and I also believe there's another small issue that could be fixed in reconsideration. Can I bring this up in my response? The short answer is yes, you can. The court has discretion if they want to consider your issue as well. I think it's very different, right, if it's a significant issue versus a small issue. If it's a significant issue, likely I would advise that you file your own motion for reconsideration, right? But I think the other party's motion for reconsideration does give you the ability to speak on a potential issue if you see one. Do you need an attorney? So a lot of family law matters, if you've been kind of doing this work pro se or kind of operating in the legal system yourself, you will know that a lot of family law issues are very form driven. This is in a way done to allow people to better access the system themselves. However, revision, reconsideration, and appeal are a little procedurally more complicated and may be better suited for help from an attorney. So if you do, one thing I would suggest if you're, considering reconsideration, revision, because the timeline is so short, 10 days, best to reach out to a Beresford attorney as soon as possible. But we can really help you first decide if, it's appropriate to bring that type of motion, and then next help you move forward with it. So if you have any questions, comments, or concerns, please let me know. Again, my name is Mackenzie Bretz. I'm a family law attorney here at Beresford. My email and phone number are on the screen, and I thank you for your time. Thanks so much.